Ladies and gentlemen, we have some breaking news for you out of the Western District of Washington. Judge Kimberly Evanson, on this date, the 14th of April, 2026, entered the order regarding initial disclosures, procedures, status report, and early settlement in the case styled as Steve Goncalves et al. Versus Washington State University. Bottom line is that this court order is the blueprint for how matters are to proceed and when. We have a copy of this 9-page, very in-depth, detailed court order with so much information on our YouTube channel. We have a link on the description to this podcast episode. Go to the community page. You will be able to read this entire 9-page document for yourself. First, if you go to page number 1 under the initial scheduling dates, there are 3 sets of deadlines. The first is May 5th, 2026. This is the deadline for the Federal Rule of Civil Procedure 26F conference, meaning the parties have to confer and start discussing how they're going to build this scheduling proposed order to send to the court for the court's consideration regarding key events that are going to happen in the case. Then the initial disclosures. This is when each side has to disclose, has to put the other side on notice of important information. This is pursuant to Federal Civ Pro 26 A1 if you'd like to take a look at it. If you would like me to go over these rules in a future episode of the Indie Zone, please let me know and I will be happy to. But you're perfectly capable of looking up these rules, I believe, to learn what is implicated here. And that deadline is May 19th, 2026. And then finally, the combined joint status report and discovery plan as required. And then there is the federal rule that's cited to here and also the local rule of court, Federal Civ Pro 26 subsection F, and then the local civil rule 26F of the Western District of Washington. So sometimes what happens when you see Federal Civ Pro, FRCP, recognize that what you're looking at are rules that are promulgated uniformly for use across the country by the United States Supreme Court for use in federal cases. Local rules of court 26F might complement, it cannot contradict, it may require additional steps that the federal rule does not. That's a local rule that's passed by the United States District Court, Western District of Washington, that you'll be able to look up. The deadline for this proposed joint status report and discovery plan that goes to the court, and the court has to approve of it, and all of these deadlines due May 26th, 2026. So we see 3 KA deadlines coming up in May in this case. And then the court gives a disclaimer at the bottom of page number 1. These deadlines are pretty much cut in stone, but not really. If there is a good faith reason to ask for an extension of time, what the court is saying here is that consult with the other side, see if the other side objects or doesn't object, and then usually if there's no objection and it's a good reason to extend the deadline, the court will go ahead and grant it. If the other side has an issue with it, if it's too long of an extension, let's just say, or there's not good cause, they may say, no, we object to it. And then the party seeking the extension of time needs to let the court know about that. And then it'll be up to the judge whether or not to grant it. And then if defendants have appeared, there's some information here, because sometimes you may not have all the defendants before the court. Sometimes what a plaintiff will do is sue a number of defendants. It might be a corporation, it might be individuals, and they may have only been able to effectuate service of process, let's just say, on defendant number 1 and not 2 and 3. Well, if that's the case, then there's certain specific rules here when those other defendants get served. And that takes us into page number 2. And the order tells the plaintiff or plaintiff pro se, if the plaintiff's representing himself, which is not happening here, If there are any defendants who appear later, then it's your responsibility to serve this order as those defendants come into the case. Then procedural information that the parties are required to comply not just with the federal rules of civil procedure, but the local rules of court, the electronic filing procedures, and then also Judge Evanson has on her homepage additional policies and procedures that the parties are expected to comply with. Otherwise, it says here, failure to follow the local rules and the general orders may result in sanctions, and no one wants that. And then there's a section, chamber procedures, communications with chambers, if there is a situation that happens. The example that's given here, a settlement, then the parties should contact Judge Evanson's courtroom deputy, and that person's email address here is given on page number 2 with the information. Now, it can't be ex parte. You should copy the other side on any communications. And obviously, there's not going to be communication with the judge directly because of the prohibition of an ex parte communication. That's where one side has the judge's ear and the other side is not there. So in any event, the other side needs to be copied in the event that one side needs to speak with the courtroom deputy for some reason or another. And then it gets into courtesy copies. During the course of proceedings, there are motions that are filed. For example, this order talks about future motions in limine. And when they're filed and served, they go right on to the court docket through the federal filing system. It's called CMECF. But the judge doesn't necessarily always get notified. Sometimes the clerk will notify the judge if, for example, there's an amended complaint that comes across the wire. But a courtesy copy is where, let's say there's a motion in limine that's coming up and it's really complicated. It goes into a lot of details. There's all sorts of exhibits. A courtesy copy would go to chambers, would go to the judge. And again, obviously, the other side gets copied on that so that the judge gets a heads up as to what this is all about and has a courtesy copy for reference to look at. And then it goes into cross motions. The court, it says here, encourages parties filing cross motions to agree to an alternate briefing schedule allowing for 4 briefs. 1 cross motion, 2nd cross motion, opposition, reply, and reply. We've been saying all along in the Indie Zone channel over the past few years that we've been active that briefings, when you hear the term briefing, let's return to motions in limine. What's a motion? Application for a court order in limine, pre-trial. So this is going to be down the line when one side or the other are going to be filing in limine motions asking for a pre-trial ruling, and a lot of times this has to do with evidence. Should this evidence, judge, be able to come into the case? Yes, it should. It should be shown to the jury, and here's why. Or the other side will say, no, that evidence is irrelevant, it's prejudicial, it's confusing, it should not be allowed to come before the jury. That's what a motion in limine is. But it's just not a motion. Then there's a response that the other side has. So if it's the defense's motion in limine, the plaintiff has an opportunity to be heard with a response. And then the reply, that is the last. The initiating party, it would be the defendant in this example, coming back and replying to the response. I want to end with Section D that talks about discovery disputes. And as you read this, what this basically says is sometimes there are discovery disputes that come up, and there's all sorts of tools that parties are able to use when getting discovery from the other side. Discovery is so important. That's evidence that might be in the possession, custody, and control of the plaintiff if we're talking defense, of the defense if we're talking plaintiff. And sometimes there'll be a dispute. No, you can't have that discovery. It is privileged. It is confidential. There's some sort of a reason legally that allows me to withhold this from you. They're supposed to try to work it out. They're supposed to have good faith efforts before they go running to the court with a motion to compel, for example. We're going to go over page number in our next episode of the Indie Zone. Until next time, this is Kathy. Thank you for joining us here today.